Alrighty, folks, looks like we are live. I'm George, one of the founders of Solo. We recently changed our official name from Solo Suit to Solo. You can see that on our site. Let us know what you think about the new brand in the chat, if you would. We're going to be talking about how to settle debt lawsuits tonight. We're especially going to be talking about Unifin. If Unifin, who is a debt collector, keeps on calling you, how you can resolve that debt with them. So we're going to be talking about that. If you have any questions, put those questions into the chat. Also, let me know if there's any issues with the audio visual. Looks like everything's working good, but let me know if there's any problems. All right. So on this webinar, I reserve most of the time for questions from you. So if you have any questions, put those into the chat now, and we'll be able to get to those in just a minute. All right, so the general idea here, most people come to the webinar because they've been sued for a debt. They might not have been sued yet. You might just be in regular collections, like pre-lit is what we call it in the industry. So you're welcome here as well. We can help you out. But let's say you've been sued for a debt. You're going to want to use Solo Suit to create a response to the lawsuit. You can generate that with our software and then have an attorney review it and get it filed in court. So we do that all the time, help lots of people all across the US. We've helped people respond to over $1.5 billion in debt lawsuits to date. All right, so you're in good company. And then once people respond to the lawsuit, most people want to settle the lawsuit. They recognize that's usually the best outcome, especially if they recognize that they owe the debt. Usually settlement's going to be the better option, or the best option, even better than dismissal. So you can use our platform Solo Settle to send an offer to the collector and get that wrapped up. So you can sign the settlement agreement on our platform, then you can even make payments. You can turn on auto pay to pay the collector consistently every month until the full debt is paid off. Or you can settle with a lump sum payment, try to get it wrapped up quicker. So we have lots of people on the chat or on the webinar on the show today. So go ahead and get your question in, and we'll try to get to responding to it. All right, so we have a question here from Jesse. When a debt collector buys debt and then sells it again, say 3 more times, then can the debt go back to the original creditor? Jesse, that's an interesting one. I haven't heard that exact question before. Can the debt be sold 3 times and then on the 4th time or 5th time, I imagine, go back to the collector? That's interesting. I see no reason why it couldn't go back to it. I haven't seen that happen myself before, but I can't think of any reason why the debt wouldn't be able to be bought by the original creditor in this case. I believe that debt buying is a regulated practice. I'm not sure off the top of my head if you need a license to do that. So there's debt buyers like Midland Funding and such, right, or Portfolio Recovery Associates. They're bona fide debt buyers. They're definitely able to buy debt, but like would a bank like Chase Bank be able to buy the debt that was originally with them back? Probably, but I'm not too sure. I guess in your case, Jesse, you're probably asking because it happened on your account. If it happened, I would imagine that it happened legally, but certainly something you could look into further. If you're being sued for the debt, I certainly wouldn't rely on the slim chance that it's somehow not a bona fide transaction because the original creditor bought the debt. You're definitely going to want to respond. Even if that was the case, like the debt or the case is somehow invalid because of that, you're not going to win unless you respond to the lawsuit. All right, so you're going to want to respond, and then most likely if it's a debt you recognize, you're probably just going to want to try to get it settled. Cases oftentimes in lawsuits, they settle for more once a case is in a lawsuit than they do pre-lawsuit. That's because the creditor has taken on a lot more cost at this stage, so they have to settle for a higher amount. So settlements oftentimes around 70% once they're in a lawsuit. Sometimes they're lower, sometimes we see 50%, sometimes we see the debt totally forgiven. We've seen people settle for like 0% on the platform. Usually things are going to settle around 70%. All right, so that means like a 30% reduction for you, so that's a big win. So there you go. Those are some of the basics there, Jesse. Feel free to ask a follow-up question if you want. So we got another question from Glenn. Hi everyone, my name is Glenn. Hi Glenn. I'm not a disabled veteran being sued for credit. I am a disabled veteran being sued for credit card debt. My only source of income is my VA income. What can I do to win this case? Well, sorry to hear about your situation, Glenn. Thank you for your service, certainly. So as a veteran, you might want to check in. It would probably just take some research on your end to look into protections for veterans in your state. Sometimes, and I think even in federal law, there's some outlines or protections in debt-related matters for veterans. So I want to look into that. And then what can you do to win? So if you expect to be disabled for the rest of your life, then there might not be much here for the collector to get at. And if you explain that to the collector, they might drop your case, they might forgive the debt. I'm not sure off the top of my head whether VA income is garnishable. It's probably treated like Social Security income, in which case it wouldn't be garnishable. However, I'm not certain of that. And even if it isn't legally garnishable, it's still up to you to protect your income. So you'll want to file a response to the lawsuit, and then you can offer to settle if you have any funds available at all to try to get a settlement here. And if you expect to make income again besides the VA income, it's probably a good move to settle now, because judgments last pretty much forever. Even after they expire, they can be renewed pretty much infinitely in most every state. So if you make income again in the future, they'll be able to come after you for that. So a good move to settle now if you can. Oftentimes, depending on your situation, collectors are oftentimes tapped in and like sensitive people to this kind of thing, to sensitive to financial matters, and they may very well work with you to get onto a payment plan that'll work for you to get this debt paid off. So you can use our product, Solo Settle, our debt resolution marketplace, to get that done. So you can make an offer on Solo Settle. I'll go ahead and put that link into the chat. It's just solosuit.com/solosettle. So you can go over there and make an offer to settle the case after you file a response. Okay, moving on to the next question. I filed a motion to compel arbitration. The plaintiff responded that the credit card agreement is hearsay, that it didn't lay the proper foundation. So you filed a motion to compel arbitration. Presumably you filed an answer already, and also you're probably being sued for a debt in this situation. So the plaintiff then responded, so the collector in this case, responded saying the credit card agreement is hearsay. That doesn't make a whole lot of sense to me off the cuff, that I didn't lay the proper foundation. Okay, I'm not sure how the credit card agreement would be hearsay in this situation. It's probably a documented contract. If you haven't already, you can find your credit card agreement on the CFPB database. Hannah, maybe you could link to that. Hannah is our wonderful assistant on the chat today. She's responding to many of you verbally. In written format in the chat. I'll be responding to you verbally. Hannah, maybe you could link to the CFPB database of credit card agreements. So that's something to keep in mind here. And Glenn, a couple of notes strategically here. So what we're actually seeing working the best, most people that are on Solo want to settle, right? They recognize they owe the debt. recognize settlement is better than dismissal, and they want to settle. So what we're actually seeing is that the motion to compel arbitration oftentimes doesn't do a good job of progressing settlement in a situation where a person owes the debt. All right. So if you don't owe the debt, by all means, file a motion to compel arbitration, try to get this case resolved outside of court. But if you do owe the debt, the settlement agreement, the motion to compel arbitration isn't necessarily helping people get there. So what we actually recommend is just filing an answer to the lawsuit and then making an offer to settle and trying to get it settled there. Great, and the reason that people are really leaning more towards settlement even more than dismissal is because if a case is dismissed, that doesn't mean you don't owe the debt. It just means that the case was dismissed. It doesn't mean you even won the lawsuit. This means the case was removed from court. So usually it's dismissed without prejudice, which means that the collector can sue you again for the case. This doesn't violate a double jeopardy protection because you didn't win the case. The case was just withdrawn or kicked out of court. So they can sue you again. They oftentimes do sue you again. And also the collector can still try to collect on the debt outside of the lawsuit, outside of court. And that is something that happens as well. So settlement actually gets the case fully resolved, gets the debt fully resolved, right? The lawsuit and the debt are two different things. It gets both of them resolved when you settle. It also improves your credit score. So a lot of people who come to us have a credit score in the 500s, which is low credit because there's an active lawsuit against them for an unpaid debt. That's reported to the credit bureaus. When a debt is settled, there'll be a bit of a boost. That's much better than having a delinquent debt in collections. It's also much better than having a judgment against you. So having the debt settled will give a bit of a boost in the credit score. And a lot of our customers on Solo are mindful of their credit scores. They want to improve it. They want to be able to have credit again in the future. So that's helpful. So settling is best for that as well. All right, moving on to the next question here. Let's see. So we have one from Talib. Talib says, I was never served by Midland Credit Management. There was a judgment issued against me. My wages were garnished. I asked for paperwork through my job, but the paperwork wasn't available. I filed a CFPB complaint, maybe against MCM, but they said they sent all paperwork to a mystery address. Do I need a lawyer? All right, Talib, yes, this is a situation that we hear about, unfortunately, far too often. Debt collectors, especially like the medium-sized and the big ones, try really hard to make sure that this doesn't happen. However, unfortunately, we get people that say that it does happen. They report it happening on our site. So it sounds like really what this is a result of is what we call sewer service. So you weren't served properly. Basically, the lawsuit documents never got to you. You weren't actually served. And then you lost the lawsuit, and your wages are being garnished. And that's the first time that you've heard about this debt. This is something that we hear about pretty regularly on this show. So, sorry this has happened to you. There's a couple possibilities. Maybe you were served with these documents. Maybe they came in the mail. Maybe you didn't know that it was a legit document. Maybe you threw it out in the trash. Right? Oftentimes, unfortunately, these debt lawsuits actually look kind of spammy and somewhat scammy even when people receive them. They look so scammy that the state of New York actually puts a huge header on the top of all of their documents saying, this is not a scam. do not throw out these documents, which of course ironically makes it look like a scam even more. So a lot of people will end up throwing these documents out. Maybe that's not what happened here. Maybe the wrong person was served. Maybe it was like an old address. All kinds of things could have happened here. So, long story short, though, we do see a pretty good success rate with people filing a motion to set aside judgment. So you can file a motion to set aside judgment and then file an answer document into court and have a kind of a retry here and then try to settle the case. You can also try settling the case now, right? So oftentimes collectors will take the settlement even if there is a garnishment active. And that's mostly because settlement's a bit easier for them, lower cost than actively garnishing. It'll probably be a settlement for the balance in full. Maybe you can get away with like payments that are lower than the monthly garnishment amount, right? So that's maybe something you could get away with. Okay, so those are some options there. So you might want to file a motion to set aside judgment along with an answer document and then settle the case. You could also just try settling the case right now, even though there's an active garnishment. Next question from Jesse. I received 3 different collection letters on the same debt. Now the third, which is a law firm, saying they are representing the creditor. When they sent the letter requesting payment, and I requested it. I requested proof of debt. They didn't return proof. Now they have gone to the court. So I did respond, and I'm asking for the contract. All right, I'm not sure I followed all of that. Let's see if I can piece this together. Okay, so you received 3 different collection letters for the same debt. Okay, that's not totally unusual. I suppose if you received 3, why haven't you responded to the first 2? It's a little bit of a question mark there, probably because you have a lot going on, I imagine, and are a bit overwhelmed. So now this third letter is from a law firm. Presumably that's different than the first 2 letters. And the law firm saying they're representing the creditor. Okay, so that's a pretty common situation. So oftentimes, like, you have a creditor. The creditor might try collecting themselves, and then if they can't collect, they'll send it to an agency. Then the agency will try to collect, and if they can't collect, the creditor will place it with a law firm. And then the law firm will try to collect pre-litigation. So some law firm, it depends on the law firm. Some will try to collect pre-litigation. Some will just pretty much immediately sue for the debt. Just depends on the law firm. So they're trying to collect, but if it's with a law firm, that is a very big indicator that they are willing to sue you for the debt. And they're probably planning on it. When they sent the letter requesting payment, okay, so they sent you a letter, you requested proof of the debt, they didn't return proof, now they went to court, so you responded and asking for the contract. Okay, so it sounds like you sent maybe a debt validation letter, but they didn't respond and instead just sued you for the debt. So I believe that is, let's see. So if you send them a debt validation letter, it has to be within 30 days of receiving their first debt collection attempt. If it's not, they can basically ignore it as far as I know under the FTCPA. And then, but if you do send them that, they're required to validate the debt. So again, this is kind of zooming out to big picture strategy here. What we're seeing actually work is not so much like putting up barriers to the collector, but really just trying to actively settle and work with them. Oftentimes barriers make it more expensive, which actually increases the low amount that they're willing to settle for. So if a debt is in pre-litigation, so it's not, you haven't been sued for it yet, we actually recommend just making an offer to settle on solo settle. You can settle debts that are in collections on solo settle rather than sending the debt validation letter to them. So that's something to keep in mind. And then you're saying that they sued you. So if they actually sued you, you're going to want to make sure you file an official answer document in court. Okay, you said that you responded. They're asking for a contract. It's not super clear if you actually filed an answer document in court or not. But you will want to do that. You'll want to get that document filed in court. You can use SoloSuit to generate that answer using our software. Then we'll have an attorney review it for you. We'll file it in court for you and get that all taken care of. And on the answer document, you can request that they show proof of the debt. Also, that will be required for them to win this lawsuit. So those are some points there. And again, if you owe this debt, probably your best resolution is going to be to settle it. Excuse me. It's the cough time of the year here. Okay, so let's see. Next question. We have one from Glenn. Again, thank you. I do not own a home, but I do own my vehicle. Can the collector go after my vehicle? Great question, Glenn. I believe so. A little bit fuzzy on this, but I believe that they can. I believe it might depend on the state. But I believe that they can enter a lien on your vehicle if the debt is related to the vehicle, like it was an auto loan. They will be able to repossess the vehicle for sure. If not, I believe they can get a lien on the vehicle. So when you sell the vehicle, some portion of that money will have to go to the collector. All right, next question. We have a question here from Jen. Question. I cannot pay the total to get back in good standing before credit card is closed. What can be done? Okay, so it sounds like you're pretty early in the debt process. Maybe you have a credit card, has some unpaid balance on it. Maybe you haven't been making payments on it, and they're saying that it's going to be charged off and closed, perhaps. You're probably worried about the impact of that on your credit. Maybe your credit is in like the 600s right now. And they're saying you need to pay the total balance in order for them to not close it. It seems like maybe that's a matter of negotiation. You might want to try to negotiate with them further. Say, hey, I just can't pay the balance, but I'd like to pay you something rather than have you sell that to somebody else. Might want to try to get onto like $100 a month payments, or maybe less than that if you can. And hopefully that'll keep the account open, or at least with that original creditor. If you haven't called into the credit card to the bank, you'll want to do that and try to tell them you want to get payments back on track. Sometimes it can be real difficult dealing with these Leviathan organizations and getting these things resolved over the phone. So it may very well be charged off and sold to a collector despite your best efforts. In which case, again, once you find out who it's with, you probably want to settle that as well. Some apps provide credit monitoring that might be able to tell you who the debt gets placed with if the bank does sell it off. And you can probably even contact them proactively and try to get that wrapped up. Alrighty, so those are some things to think about. All right, folks, well, we are half past the hour. This is the solo webinar. Thanks for coming on. I'm George, one of the founders. It's been a pleasure talking with all you guys today. Again, sorry about the situation that all of you are in. You know, it's a tough situation to be in. We are here to help you out. We want to help you get all this debt resolved and get you back on the right track. All right, thanks so much for coming in. You can always email us at support@solosuit.com. We do this webinar about once a week, so you can come back next Wednesday. Alrighty, thank you all. Take care.